All right, and I think we're all set. The next two speakers are in person, and they're going to talk about codifying the law. This is Nell and Jeffrey.
Yeah. Hi, everybody. So again, my name is Jeffrey Bilik. I'm a PhD student in sociology. This is Nell Escher. We are both working at the Computational Human-Computer Interaction Lab at the University of Michigan. Nell is a third-year PhD student in computer science and a JD. Today we'll be presenting some very preliminary findings from our work on legal advice software titled Codifying the Law. This is a project that involves a lot of co-authors, including also other folks in CS and law, but we have a lot of work ahead of us. So to just talk about some of the framing for this project, it's around online legal advice tools. So these are tools created by public and private actors that provide automated advice to layperson users about the applicability of a law to their situation. Now, the potential of these tools is that they can improve access to the legal system. So people who cannot afford lawyers, for instance, can instead consult these tools for guidance and advice, similar to some of the tools that were discussed earlier today in this workshop. And the way that many of these tools work in this one sort of real-life example of a private tool is that they solicit information from a user and they provide some sort of output about whether a law applies to them. So in this example, this is a tool that tells the user whether they are subject to an immigrant visa ban that was issued under former President Donald Trump in 2020. Now, despite the promise of these tools, what our lab, in work that Nell Escher has co-authored, has found in the past, as well as other prior literature has found, is that these tools often have major errors. So in this prior project, we audited a Pennsylvania state website that provided advice to households on whether they were eligible or not to receive public benefits. That is healthcare, childcare, food assistance, etc. And what we found was that the tool issued incorrect advice, which could have discouraged eligible households from applying for assistance. So we could see that there were errors in these sorts of tools, but it was very unclear why these errors actually emerged. And this has other sorts of implications. It becomes difficult to potentially appeal or look for legal recourse when you have these sorts of errors, despite the fact that they shape sort of material and social outcomes. So this project really tries to get to that question. Why is it that these errors actually appear in the process of creating these tools? How do legal and programming experts actually translate legal text into computer code? Now, what prior literature tells us is that this isn't a very easy question to answer. There's always a level of interpretation involved in the translation of law into code. Although it can vary in sort of the degree of determinacy, for instance, design always potentially embeds values. There's also an absence of widely adapted standards or methods of verifying whether a legal advice tool is actually adopting the law properly. And again, literature tells us that many different factors might be involved in the decisions that specific teams use. These range from the structure of the legal text, to the selection of the programming language, to the domain expertise of those involved, to specific points of team dynamics. And so to try and approach some of these issues, we really, again, try to look down into the everyday, the actual sort of live production of these tools and the decision-making of those involved. This allows us to look at how errors are introduced in these tools, again, in real time, as well as how the decision-making encoded in these tools may be different from the decision-making that judicial actors, including judges and lawyers, use in interpreting and creating the law. So to specifically think about what we did for our project, we are using a qualitative design. This is an ongoing experimental study where we have teams made up of advanced students in CS and law. These are students who have both industry experience and relevant domain expertise. And we ask them to essentially create these sorts of legal advice tools. These participant interactions are fully recorded, transcribed, and coded. We also code snapshots of the evolution of the code over time, as well as, of course, have the final artifacts that they create. These test across some theoretically important conditions, including team dynamics, domain expertise, and ambiguity in legal text in ways that I'll speak about in just a moment. So our participants are students affiliated across University of Michigan campuses, And we split this into 3 study conditions. So we've conducted thus far 5 teams that are simply 1 advanced CS student building this legal advice tool, 4 teams of 2 advanced CS students, and 6 teams of 1 advanced CS and 1 law student. And although these might seem like this might seem like a small sample thus far, just a reminder that this is all in all about 100 hours of recorded audio and video that we've collected, including chat logs, website visits, all sorts of discussion that need to be transcribed, coded, etc. So although we are trying to get more trials running, we think that we can have a lot of interesting findings out of what we've put together thus far. So how does the study actually work? So essentially, we give our teams 4 hours to complete 2 major tasks. The first, much shorter, is a warm-up task. This is something we call dressing for the weather, should you wear a coat, where we just ask them to put together a very brief 3-question maximum tool that tells the user whether they should put on a coat based on the weather outside. This helps familiarize the team with the provided starter code that we'll talk about in a moment, and works to begin to establish team rapport. And then the major task, which is to create this legal advice tool based on provisions in the Federal Bankruptcy Act, which we will talk about in a moment. But suffice to say for now that we chose these provisions. We chose this excerpt because it contains multiple provisions that cover different conditions, which allow us to see how different teams might deal with different forms of tool logic. And it contains legally ambiguous language that there's judicial controversy over. So we can see how these teams may interpret the same language in different ways. So to talk about the specifics of a tool and some of the early findings, I'll hand this over to Nell.
Thank you. So earlier, Jeff showed a screenshot of a tool that gave advice about immigration rules. We provided starter code for both tasks that was informed by the design of such existing legal advice tools. So a series of questions and then some response. I wrote the CSS and the routing so that the participants could focus on the legal encoding task. And since this is a web application, we wanted to use languages in which the participants were already proficient. We have our participants coding in JavaScript and HTML. This accords with our experience from our previous research project on the Pennsylvania State Legal Advice Tool, where the front end was written in Angular, a JavaScript framework, and we don't know how the back end was constructed. So we are not using a domain-specific language here, but the results we're going to present may serve as a motivation for developing and adopting such languages. This is one of the tools that was produced during the study. Participants are fairly unconstrained. They design the front-end experience by adding any sort of HTML input element and write the back-end code, which takes in the user's input values and returns a message about whether or not this law applies to them. These are the legal provisions that are covered in the task. These are US laws. We're discussing the US context in this talk. And so they lay out some of the rules about which debts may be forgiven in bankruptcy. Bankruptcy is a legal process through which a person who cannot repay their debts may be freed from that debt. Specifically, these rules concern debts incurred due to fraud, domestic support obligations, or student loans. These debts are typically not forgiven. If you go through bankruptcy, you still got to pay those debts back. But crucially, a person can have different types of debts when they file for bankruptcy. So they might have an unpaid utilities debt and a child support debt. That unpaid utilities could be discharged by going through bankruptcy, but that child support debt would not be dischargeable. Our initial analysis of the final tools produced in the study shows that most of them have an incorrect structure. They all ask about each type of debt, that fraud, domestic support, or student loan debt. But for most of them, if you indicate that you have one kind of non-dischargeable debt, the tool response will say that all of your debts are non-dischargeable. Only 3 of the 15 tools consider each debt separately with a specific message about the applicability of each provision to different kinds of debts. So very few capture the way that bankruptcy law currently works, where some debts may be dischargeable and others not. Our observations captured how some of these tools went awry. In one law and computer science team, the law participants suggested that the tool should be structured such that the user would receive advice on each possible type of debt, even going so far as to create a flowchart about how the tool should operate. And their teammate agreed to this structure, but then ignored it. They implemented a tool that used that all or nothing logic anyway. In other words, we should not assume that the intent of a participant alone translates into the design. There may be additional gaps caused by different training and domain knowledge. That law student, at the end of the trial, did suggest a couple test cases to evaluate the final tool, but ended up not catching that error. Most of the law students in our study did propose test cases, but they never covered all the possible logical branches of the tools that they designed with the computer science students. Another aspect of this legal text that we've analyzed is the treatment of an ambiguous phrase, something that has multiple possible meanings. As an exercise for the programmers in the audience, see if you can find which phrase has been the subject of conflicting legal interpretations in the higher courts. It's 2 words. Right, if you thought undue hardship, give yourself a pat on the back. If you're considering a career change, maybe go take the LSATs. Undue hardship has been the subject of a lot of judicial debate. In the US, judges can decide what an ambiguous statute means and how it applies to individual cases. While the language of provision may permit multiple interpretations, judges are meant to weigh the competing interpretations based on how they accord with fairness or maybe intent or the precedent. Student loan debt can be discharged in bankruptcy if repaying it would cause undue hardship to the debtor. But what does undue hardship mean here? Judges have looked at the intent of the lawmakers in interpreting this term. Repaying student loans isn't pleasant for anyone, but Congress didn't want to make it such that any recent grad could just file for bankruptcy and waive their student loans away. So judges developed different tests that they apply to determine when repaying student loans causes undue hardship. One such test is called the Brunner test, under which student loans are discharged if you cannot maintain a minimal standard of living if forced to repay your loans, your financial situation is likely to continue throughout the repayment period, and you've so far made a good faith effort to repay your loans. The totality of the circumstances test is another test that considers an even broader range of factors. So there's room for judges to disagree about whether a particular debtor would face undue hardship, but their decision is guided by this reasoning that has been developed across thousands of bankruptcy cases in conversation with legal scholars and other interested parties. For the tools built thus far in our study by computer science participants working alone, we observed that they push this ambiguity out to the user rather than resolving it internally. They ask the user, do you think there's undue hardship in this situation? But for the computer science and law teams, they typically discover the existing judicial tests while doing legal research during the task. They see that there's, the Brunner test or the totality of the circumstances test, and they typically select one or the other to encode in their tool. So this team was like, let's just repeat the Brunner language. For other computer science and law teams, they actually provided a static list of things that courts have weighed in the past. So check here if the debtor has a permanent illness, check here if they have numerous dependents. This particular list is based on the first 5 cases that showed up in the law student's LexisNexis search. So the research engines that participants consulted absolutely had an impact on these tools, with the top cases presented by the search algorithm shaping what ends up getting included in the final tool artifact. The computational legal tools built in this study decide cases very differently than judges do. They aren't giving a debtor a chance to present their individual circumstances. Instead, they are flat. They only consider what judges have done in the past and repeat it for all future cases, or they just kind of ignore the ambiguity altogether. Legal software may select a permissible interpretation as it fixes legal text in computer code, but we didn't observe any of that moral grappling taking place as they were constructing these tools. So it can undermine the very reason we might want to have a legal system in the first place rather than arbitrarily settling disputes, like with a coin flip. And this matters quite a lot because the students who participate in our study are quite confident that they captured the spirit of the law in these tools. After they completed the main study task, our participants filled out a brief follow-up survey, and a majority of both computer science and law students agreed to publicly post their tools to be used by people who are wondering whether to file for bankruptcy, even though the tools that they created were generally not that great. Then we probed even deeper with our survey. Though we have seen a lot of legal advice tools in the US context, we haven't yet seen the complete displacement of judges by software. But other countries seem to be experimenting, so we thought we'd poll our participants. We asked them, would you like to offer your tool for use in determining the outcome of court cases? It would be used by court clerks without legal training. They would record your software output as the official outcome. This would reduce the workload of judges. While 15 out of 19 programmers agreed to install their tool as a decider in courts, none of the legal experts did. Legal experts and programmers differed in their opinions on the appropriate roles for these tools. So we have judicial reasoning, centuries of debate about what is fair and what is good governance, being displaced by the naive understandings of our participants. Computer science students aren't able to recognize the boundaries of their own expertise and where they're entering a domain that already has carefully considered processes and rules. Law students are much more sensitive to these aspects of the law, but they're not always able to assess whether a tool accords with the law, and they definitely don't know how to put together comprehensive test suites. When confronted with an ambiguous provision, the participants treated it differently than judges do. They would settle on an interpretation by chatting with their teammate or by Googling stuff, and disregard many legal rules like jurisdiction in the process. And while most participants seem to have been overconfident in their legal advice products, computer science students took it even further, believing that their tools could replace bankruptcy judges outright. So as we mentioned, we have only presented very preliminary findings, and we still have many, many months of analysis and qualitative coding ahead of us, but we do plan to look more closely at the effects of race and gender, and the sources consulted in creating these tools, whether it's LexisNexis, Westlaw, law blogs, Google, Webster's Dictionary, and to also try to find patterns across the different trials. We also plan to conduct an MTurk study where we will present workers with one of the tools and then a short set of facts about the debtor. We want to know how the MTurk answers will answer the questions, understand the responses, and whether they trust those responses. So that is our project thus far. We would absolutely welcome any suggestions from this audience about what we might pay attention to as we analyze this data. Again, this is Jeff. My name is Nell. I'm looking for internships. Thank you so much.
All right, great. Thanks for a fascinating talk. Any questions in the room to begin with?
Hi, thank you guys. That was a great talk. I'm curious about you said that you had lots and lots and lots of recordings and footage of the actual trials that you ran. I'm curious if you have any insights about sort of potential communication barriers between the computer scientists and the lawyers in the room, because it seemed like there were difficulties in sort of transferring ideas across, but I'm curious if there were more like the computer scientists deciding that we will sort of ignore the lawyer's advice to put in the sort of statutory or the interpretive language or whatever, or if it was sort of just there were actual barriers because of terms of art or stuff like that. Did you notice stuff like that, or do you have any insights on how to potentially lower that kind of barrier? Thanks.
It's a great question. Thank you. So I think that one of the things that we noticed was that, for instance, in law and CS teams, the law students would very often treat CS students as laypersons in terms of explaining how the law works. And the logic that they developed was sort of through the direct conversations that they had with CS students and trying to work out with that CS student sort of, here is what defalcation is, here is what undue hardship might mean. So a lot of those design decisions were made through examples that the law student felt sort of compelled to use in those cases. Do you have another example?
So we never explicitly have a computer science student saying, thanks for saying that, I'm going to ignore that advice. But we do observe that pattern of behavior happening. So we do have coded some discussions over chats, which then if you look at what the code is that gets written, it's just completely different from what is discussed. And I think that what some of the previous talks have discussed comes into play here. Cross-training. We specifically selected these participants so that the law students had never coded before, and then the computer science students had never taken a legal class before. So if there is some way to get them on the same page, I'm not sure what that looks like. I think there's potential for a lot of future work there.
Cool.
So this is great work, by the way. You brought up test cases a couple of times. Did you provide any of the teams with test cases, or did you encourage them to write their own to make sure they were doing the right thing?
So we left it entirely up to the teams. Some teams didn't attempt test cases whatsoever. Some teams did. All of the teams did submit a final project within the 4 hours. We also gave them an extra hour, so up to 5. So they all submitted tools that they were at least felt pleased enough with to give to us. But it was entirely up to them how to test those tools.
Yes, and by test cases, I'm kind of using that term loosely when it comes to the law students providing those. They're looking at the questions provided and saying, okay, if you put in these answers, what's the response? And they'll go through the tool 2 or 3 times, but that's just not enough to get full coverage of the tool.
Okay, there's a lot of questions online, so I'm going to start with the first one, and I'm going to read it back to you because it's not showing on the screen here in the room. During pair programming sessions involving a lawyer and a programmer, do the lawyers look at the code in any way? Do the discussions revolve around the code and logic rules in the abstract, or do they focus on practical examples from test cases?
That's interesting. Some of this, we still need to look through some of the studies that we've conducted. We have had cases where lawyers have sort of a lay understanding of how they want the logic to look like in code. So they sort of give suggestions for how the code should be structured. And they often provide the text for sort of the questions that the CS students encode. But there's a range. In some cases, the lawyers didn't look at the code at all or didn't ask about the sort of finished tool, sort of trusted the CS participant with what they put together.
So for this study, we have not considered that yet, but I think that'd be a great future step. We just kind of wanted to see as a baseline. As part of our previous research, we did a lot of interviews with people who developed legal advice tools, who worked with nonprofits, and the teams that they described to us were someone who's a legal expert working with someone far away, typically, who knew how to code. And so we wanted to model it based on that. I think if we wanted to see improvement from that baseline, having that sort of education of lawyers on the legal code, that would definitely be a great path forward.
So I think one of the differences that we saw were just in terms of the logic that they encoded that we talked about a bit earlier. So whether they recognized that individuals could have different sorts of debt or not. Also, in terms of the kinds of interpretation, there were a few cases where CS students working alone were able to find instances of things like the Brunner test or the totality of circumstances test. But for the most part, their questions and their answers wouldn't try to articulate these kinds of issues. Oh, sorry. But, do you have a question? Or?
Sorry, I guess this would depend on whether this question is about the answers on the final survey or the answers in the tool itself. If it comes to answers on the final survey, I don't think we have enough evidence so far to say it's like a statistically significant difference. But generally, the lawyers don't seem to have kind of communicated over the course of the 4 hours any of the cautions that should be taken in doing these tools. A lot of the computer scientists and the computer science and law teams, they said, yeah, go ahead, this would be a great decider. So the few computer science students who were like, maybe we shouldn't have robot judges, some of them worked alone or in pairs, not necessarily always with a lawyer.